Yes, Ms Murphy.
My ladies, my lord. The young woman who is the respondent in this appeal seeks a remedy for real suffering, emotional, psychiatric, and financial suffering, caused to her by the appellant's failure to protect her confidential location, breaches that were in contravention of their duties in relation to her confidential data, and in breach of their operational and system duties to protect her from a present and continuing risk to her life and or of treatment in contravention of Article 3 and or in breach of the negative obligation under Article 8 not to directly interfere with her qualified rights under Article 8 other than in accordance with law and so far as is necessary in a democratic society. Current societal expectations in respect of a young woman who finds herself in the situation that she did are expressed, although far from solely there, in the Istanbul Convention. And we note in particular, invite you to note in particular, Article 56 at Authorities Bundle, final volume, page 2016. The significant societal shift that has occurred over the last several decades is to place expectations upon the appellants to proactively protect women from repeat victimization. That, we say, is important context in the context of this appeal. You, my ladies, my lord, will hold in mind throughout the preeminent public interest in not denying this young woman a remedy, unless you are compelled to conclude that an immunity of the breadth contended to by the appellants is truly necessary. As to our approach, we intend to develop our submissions first by addressing the facts. The matters that we will emphasize here are, first, the substantive uncertainty as to the circumstances in which confidence was not maintained in the respondent's address, and which in Mr. Justice Ritchie's unimpeachable conclusion rendered this claim unsuitable for strikeout. Secondly, my learned friend Mr. Beerking's counsel's procedural point regarding Mr. Justice Ritchie's observation at paragraph 112 of his judgment, that's Core Bundle 200, that it, quote, appears to me to be correct, unquote, that if the claim against the Crown Prosecution Service was barred, so too was the claim against the police, because, the, quote, the damage was only caused when the address was disclosed, and that only occurred in court. So we're going to look at the facts on that point predominantly. Thirdly, to address Mr. Beer's submission that the provision by his client of XGY's confidential address was a matter compelled by statutory guidance, the director's guidance, and in particular the documents that must accompany the MG3 report, including the domestic violence checklist, and my learned friend's related definition of the scope of the immunity that was asserted yesterday and to which we will return. And finally, so far as the facts are concerned, we will rely on those to address my learned friends, Ms. Wolfe and Mr. Goss' submissions on the summary judgment point. After our consideration of the facts, secondly, in relation to the legal landscape, as to witness and to the extent that it is anything other than the same, advocate's immunity. And we will primarily rely upon the three pertinent decisions of the House of Lords, all of this century, Darker in 2001, Hall and Simmons in 2002, and Jones and Caney in 2011. Underpinned by the decisions of this court in Singh and Reading in 2013, Daniels in 2015, and Crawford and Jenkins in 2016. Relying upon that material...
Sorry, underpinned, I missed the first one.
I'm sorry, in terms of the Court of Appeal case, my lady...
Just for Daniels and Crawford.
Singh and Reading,
Singh and Reading. Thank
2013.
You. Yes.
Relying upon that material, the respondents' overarching submissions are, first, that in seeking to make good their arguments in this appeal, the appellants have generalised witness immunity in a way which, in the words of Lord Hoffman in Hall and Simmons, to which we'll return, it is, quote, illegitimate and dangerous. Secondly, that irrespective of whether Hall and Simmons swept advocates' immunity away entirely, this appeal concerns novel facts. Facts that have not previously been found to fall within the scope of an existing immunity, and as such, it is for the appellants to satisfy this court that the broad immunity for which they contend is justified on public policy grounds, or to put it more accurately in the context of a strikeout application, that the respondent does not have an arguable case that it does not. Thirdly, that the first appellant's plea to a shield of such elasticity that it can spring backwards in time from anything said or done by an advocate in court to encompass all police administrative and investigative functions, all actions undertaken by them as law enforcers or investigators, irrespective of the activity's connection with the evidence, is without authority and runs counter to the general progression in the common law away from immunities to the placing of policing and prosecutorial authorities on the same footing as other defendants, especially in relation to third-party liability. Fourthly, that it is also contrary to authority to determine the scope and application of immunity on facts that are not only presented to this court on an assumed basis, but which have not even been addressed in pleading by the second appellant, which have not been adequately addressed in the evidence filed by the first appellant in support of the application for summary judgment, and without placing before the court the documents that support or undermine the first appellant and the respondent's pleaded case. And finally, still within my topic of legal landscape, that in light of the grave uncertainties as to the facts and taking proper account of the respondent's experience and the appellant's conduct, it would be entirely wrong to bring this claim to a conclusion by means of the summary procedure under Part 24.
Is that a compelling reason argument? Is that what you're advancing
It's
there?
both, my lady, both with regard to uncertainty of the facts and other compelling reason. Having addressed the legal landscape, we will turn finally to two short topics. The first addresses Dr. Van Dellen's evidence.
First addresses
Dr. Van Dellen's evidence.
Yeah.
And finally, as an exercise in drawing together the threads of what we say all of this amounts to, we will invite consideration of my learned friend's various definitions of the immunity, because the obvious first step in discharging the burden of proving that the claim falls within the scope of immunity is to define the immunity relied upon. And we rely on that exercise to support our contention that Mr. Justice Ritchie was entirely right to conclude that the respondent has an arguable case that the facts of her case do not fall within the scope of an existing immunity, to therefore consider it necessary to balance the relative public interest considerations, and to conclude that this matter ought to proceed to trial so as to provide a proper forum for the adjudication of the important issues it raises.
That's extremely helpful, and that's the concluding section. Thank you for that. Just to flag up, I hear what you say about the burden on the appellants to define the immunity, but at a convenient moment, I think it would really help us if you could say in a sentence or two precisely what you say that the proper scope of immunity is against each of the appellants on the facts of this case. And secondly, to answer the question, which I think you have already answered this morning, which is it your case that the CPS can be liable if the police are not liable? And conversely, can the police be liable if the CPS are not liable?
Madam, my lady, if I could take those in reverse order.
Yes.
Because the second question is highly fact dependent. And when I turn to the facts, I'll try and draw out why we say both of those propositions are potentially true. That the CPS can be liable without the defendant being liable, the police being liable, and vice versa. So I think
you say they don't stand or fall together.
We do say that, my lady.
And on the precise scope of the immunity that you contend for?
You had anticipated my next observation before I move on to that structure. Because we wanted to make clear, and we think this also answers the question you posed, my lady, what the respondent does not argue.
Thank you.
First, she entirely accepts that there is a threshold immunity bar in respect of evidence given in court and the preparation of evidence that it is intended will be stated in court, whether or not it is in fact relied upon, with this critical caveat, which is that only where the alleged statement constitutes the cause of action.
Sorry, only where?
The alleged statement constitutes a cause of action. And that means where the cause of action that is subsequently brought turns on that.
Turns out it is based on the cause of action. So that's why we see replete through the authorities defamation claims and the like. I have some particular submissions prepared on this, which I'll come to, but
Fine.
Essentially there is reiteration of that phrase throughout the authorities, and clearly where the cause of action arises from the content of what the witness is saying, whether that is said by the witness or, our next point, said by the advocate. That's clearly within the scope of witness immunity. And as Lord Hope observes in Darker, advocates enjoy that same immunity. It's clearly not limited to defamation, causes of action based in defamation, because we have seen, as we discussed yesterday, I believe in response to my lady the President's question, there were various ingenious ways of getting around what appeared to be a limit to the immunity described by defamation, libel and slander and the like. But where the immunity was found to exist, it was because of the content of the statement, and the cause of action was based on the content of that statement. And thirdly, the respondent does not seek to draw any distinction between a cause of action based on such a statement, given in evidence, or prepared for a bail hearing as opposed to a trial. Of course, the threshold immunity would apply to the pulling together of evidence for an SHPO, a sexual harm prevention order, or probably more than a dozen, what are now probably more than a dozen other protective orders within the powers exercised by magistrates' courts.
So to that extent, you would not support the reasoning of the judge below?
No, but my lady, we don't consider it an important element of his reasoning.
And going back to your first position, does that mean that if the police officer had prepared a witness statement for the bail application, including the respondent's address, and given it to the CPS advocate, immunity would apply?
The facts in A in Hampshire, my lady.
Or the facts here. Imagine here, if this police officer had produced a witness statement with saying, I confirm that the address is whatever, and gave that to the advocate, the CPS advocate, that both would be immune.
For the purposes of this appeal and the respondent's case in the appeal, I don't need to persuade you that it would, and I don't seek to do so.
But hypothetically, would on your
On my
scoping
formulation,
of the immunity,
it would fall within the scope of immunity.
Thank you. Thank you.
May I turn then to the facts? These were set out in summary form by Mr. Justice Ritchie at paragraphs 5 to 8, and then again at paragraphs 23 to 24 of his judgment. But we emphasise that it is important what is known and what is not known about the alleged tortious conduct, and we consider it highly significant for you, my ladies, my lord, to fully understand both elements for the purposes of addressing this appeal. So forgive me, I'm going to take a little bit of time going through the facts, albeit that I entirely appreciate there's been a great deal of pre-reading and the material is familiar. So I'll try and take it at a reasonable speed, slowing down when I consider the point to be particularly important. So, of course, the events of the 6th of November, when the respondent fled the abusive relationship at 20 years of age and reported the perpetrator to the police. She was reporting then allegations of actual bodily harm, common assaults, coercive and controlling behaviour, and that he was in breach of bail in respect of other matters unrelated. And she fled first.
Sorry to interrupt you.
Not at all.
I don't want to ask any questions or get any answers that are anywhere close to confidential. But there's no information as to, on the 5th of November, geographically where XGY was. I'm assuming it wasn't Scotland or the northeast of England.
In close proximity to her grandparents' house, to which she fled, in the same county.
So, how would we describe that?
She made herself safe initially. She sought to make herself safe initially by returning to her family home, which was in fact her grandparents' home. The perpetrator was well aware of the address of that family home. He had in fact stayed there, and aspects of the violence towards the respondent had in fact occurred on those premises. And in addition to threats issued prior to her leaving the relationship, upon her leaving the relationship, he made further threats, and they were directed not only at the respondent but at her grandparents, and they included the plan to throw acid in the respondent's face and in her grandmother's face, and to burn the grandparents' home down.
So we can't know the county?
Bear with me one moment, if you wouldn't mind. I'm going to turn my my back and just check on instructions on that. I just want to be
Let's
cautious.
carry on for the time being and come back to this point. For now, let's carry on.
Yes, we'll clarify those instructions. I'd obviously prefer to take that
So,
course.
but just dealing with this as we are, your case on the facts, and obviously you want to take us through them. Your case on the facts is fully set out. In other words, the facts it's appropriate for us to look at, for the judge below to look at, fully set out in the your particulars of claim.
My lady, yes, but with this one caveat, which is that the pleading was drafted on the information that was currently available to my learned friend, Mr. Powell, when he pleaded it. And this is a case that necessarily depends a lot of information that was held by the first appellant and which has clearly not been disclosed in the proceedings, further to requests, pre-action.
There's an issue about disclosure, I take that, but so far as the Judge Brownhill was concerned, she would be, for the purposes of a strikeout, she would be looking at the case as it's pleaded.
Yes, but with
On the
the
facts.
understanding that in respect of the easier principles, one's entitled to take into account where the case is likely to go, not where in a wing and a prayer it might go. And one area that we are concerned has not been addressed by either appellant in furtherance of their responsibilities under the pre-action protocol are the assessment of risk in relation to the perpetrator, what they knew about the perpetrator, and secondly, what they knew about the system failing in respect of communications.
I appreciate there's but what we're looking at is the fact that were pleaded at the time, and you have a separate point, which is that there was an inadequate response, which I understand.
Yes, but entirely understood. Take the pleading for the purposes of the strikeout application. But the facts go a little bit further in terms of their relevance because of the manner in which my learned friend, Mr. Bearking's counsel, put his case yesterday, which was very much predicated in part, I appreciate it's not his only point, on the statutory case file building guidelines. And so, with your leave, I would like to take you through a little bit more detail what we understand to have in fact been happening when the perpetrator appeared at court in April 2020. What was in fact going on.
And where do you get that from, and where do we find it in the documents we've got?
Yes, can I take you there? Let me just jump quickly over the events of the 7th of November when the perpetrator is arrested and just the respondent is described as obviously terrified. And we do place reliance on the fact that the risk assessment, an objective risk assessment by the first appellant, placed this as a high-risk domestic violence incident. And that is perhaps obvious, bearing in mind the facts I've just outlined. On the 19th of November 2019, following being informed of the Epsom disclosure and the perpetrator having become aware of her second flight destination, the one in Epsom, and as soon as she could obtain a place in a women's refuge, she relocated there. And we place reliance, and this is really on the summary judgment point, on the fact that the first appellant did initiate a multi-agency risk assessment conference referral at that point to the locality of the women's refuge. And we say that notwithstanding the lack of reported action by the perpetrator since becoming aware of the respondent's whereabouts, the first appellant was clearly continuing to treat this as a high-risk matter. And indeed, the respondent was refusing to inform the police of her whereabouts at that time. And we, of course, have not been informed of what was going on with the perpetrator. We don't know if he was in prison. We don't know if he was evading police. The circumstances have not been made clear. We then have the next material event, which we haven't particularly highlighted in previous summations of the facts, which was on the 9th of February 2020. We can see at Supplementary Bundle 124 that on that date there was an investigation quality assurance review. It's not the only one that was undertaken in relation to the file building in respect of the common assaults. But we can see there, and this, my lady, we consider pertinent to the question as to why it might be appropriate to draw the line of immunity around witness evidence, but not to include the tortious conduct in this case, because we see there, and repeatedly through every file building exercise that one sees in these occurrence logs, not only this one, certification that the supervising detective sergeant has satisfied him or herself that, quote, no sensitive or personal information, open brackets, address, DOBs, intel, etc., has been included in a disclosable document. So we see there the checks and balances built into the system in respect of evidence.
I'm just looking at that page, and my fault, I can't see it.
Bear
So,
with me a
page
moment.
124, what is the entry I'm looking for, please?
It's the 9th of February, and
That's in the middle.
it's under the heading pre-charge advice just below the middle of the page.
Thank you. Got it.
And then we see the following page, 125, that the Crown Prosecution return their charging advice in respect of those 6 common assaults. There are several, as I say, references to case building in respect of those charges. And it appears on the 27th of February 2020, a postal requisition was authorised. So, as we understand it, he was, in essence, summoned to attend the magistrate's court in order to be charged by with those offences. And he failed to appear, but that's another part of the background. It doesn't relate to the 16th of April events. So then we come forward to the 15th of April 2020, and we can see that the perpetrator was arrested for interview in connection with the additional extremely serious allegation made by XYG, but separately for breach of court-imposed bail conditions in an entirely separate matter. And it's in respect of the former XGY's allegation that the police bail conditions were imposed. And those were the ones who did not reference the Hampshire address. That having been agreed with XGP. I'm now muddling up my YP, I apologise. We then have the perpetrator appearing at Brighton Remand Court and the bail condition being imposed that he could not attend the address in Hampshire. And my ladies, my lord, I'm sure you've looked at this with care. It's at 128 to 129, the aftermath. And what is material there and not entirely apparent behind the redactions is that the officer in the case took very proactive steps to get in touch with the local authority housing team and say that she needed to be rehoused. And that chimes with that single combined assessment of risk form, which we see at 136, with the allegations being classified as most serious crime, and with references to the threats to kill, the drugs, the violence, previous domestic violence, guns, and risks to the victim being high.
This is November 2019. Oh no, what is the date of this document?
Yes, it is, my lady, it's a November document.
Right.
It's reviewed at various stages, contemporaneous with that initial assessment. It's never downgraded. My lady, it may have already been considered, but just in case it has not, in your pre-reading, you have at Supplementary Bundle 163, the MG11 in respect of the common assaults. And just to give a flavour of the severity of these allegations, over the page at 164, we see an argument commencing in the bedroom at the grandparents' house, and we see the nature and seriousness of the physical assault, with a degree of suffocation and with things being thrown, including heavy jars. And more seriously still, over at page S165, we see very threatening comments arising from XGY's choice of car to collect him in. And that descending into threats, very serious threats in respect of XGY's physical safety and the car, escalating to his going berserk, smashing the car up, breaking the indicator stock, slapping XGY across the face, forcing her to stop and pull over, and culminating in driving the car at her. So we are really dealing with very serious violence. As
And
a
the dates of these were, this is the statement, what were the dates given?
The date of that incident was the 9th of September, 2019.
Thank you.
Just as part of the background chronology, at Supplementary Bundle 82, we have the reassurance from the second appellant that they will disclose all relevant documents within the next 7 days. That's right.
82, which is the bit?
Yes, it's just right at the bottom, pre-action disclosure is the heading.
Yeah.
And my instructing solicitor, Ms. Spender, chasing that up. We see that at 87, with just over the page between 86, top of 87, seeking all of the information before the Crown Prosecution Service advocate and documents pertaining to this systems failing that we have previously mentioned. No disclosure from the second appellant. And so far as the first appellant is concerned, that is, of course, limited to those documents that, or in broad terms, limited to the documents exhibited to Mr. Rutherford's statement. My ladies, my lord, we do consider the content of XGY's complaint, which she penned in the immediate aftermath of the Hampshire disclosure, to be an important document in this case. It articulates more eloquently than any advocate could the real impact of the disclosure upon XGY. And that is set out at supplementary bundle 60 to 61. And it gives a flavour of the real terror and breach of trust, breach of confidence that she experienced in light of the tortious conduct that she complains.
Thank you.
Reading those documents together with the defence, and in particular paragraph 17, subparagraph 3, which is at core bundle, page 344. What we understand to be the facts is that XGY's confidential address was entered into a contact card by a police officer and transmitted to the Crown Prosecution Service as part of an electronic case file, but one that would appear to have been solely concerned with the perpetrator's breach of bail in relation to an unrelated matter, referred to in the papers as the Brighton matter. And there does appear to be a dispute of fact between the appellants as to why XGY's address was disclosed to the Crown Prosecution Service at all, to which we will return. It is at least arguable that the disclosure
Sorry,
was...
why her address was disclosed where?
to the Crown Prosecution Service in connection with that appearance at all. And it's at least arguable that the disclosure was inadvertent in the sense of there having been no intention to engage the Crown Prosecution Service in relation to the confidential location at all, and that it was provided for purely administrative purposes, in fact, errant administrative purposes. It is, however, entirely clear that the address was not disclosed in the form of a statement from XGY, nor in connection with the evidence in any way. The entry in the contact card did not form any part of the evidence before the court in respect of the breach of bail matter, nor was there ever any intention that it would be. And of course, it is therefore XGY's claim that disclosure to the Crown Prosecution Service in these circumstances, that is, circumstances that were not required by law and not justified in the public interest, were in breach of the duty not to disclose her confidential address, and that this tort was completed so far as the first appellant is concerned, when in breach of his duty not to disclose, he did disclose. Now, the Chief Constable avers that in addition to this entry in the contact details page of the court file, he provided to the Crown Prosecution Service a DA checklist, a domestic abuse checklist. Again, it is unclear why he did so on the occasion of DYP being presented to the court on an entirely separate matter, or even if this did happen, because we haven't seen the document, and no explanation has been given for not disclosing that document in these proceedings, something about which we've been complaining throughout. But what the first appellant avers is that this document included information that XGY's address was not known to the perpetrator, and that the only bail condition should be a non-contact provision for XGY and other members of her family. So that, certainly one reading of the first appellant's averments is that material was placed before the Crown Prosecution Service with regard to bail conditions in relation to XGY. But it's not clear what the Crown Prosecution saw because we haven't been given the material. But on the face of it, the police pleading sits discordantly with the Crown Prosecution Service's reply to XGY's complaint.
Could you just give me the pleading reference again? I'm sorry.
The pleading reference, yes, of course. It really all comes at paragraph 17, those averments, and that's at core bundle 344 over to 345. So the Crown Prosecution Service's reply to the respondent's complaint. This is a supplementary bundle 64. And on that account, her case was dealt with unexpectedly, and it would appear to be the CPS account that acting without instructions, the CPS advocate noticed that she did not have bail conditions and therefore applied for the, quote, usual bail conditions in cases of domestic abuse, and that the advocate was, quote, acting in her best interests. And separately, and of particular relevance to XGY's claims under the DPA and HRA, we have the additional information. And in consideration of the CPR 24 summary judgment point in particular, we invite you to note that the CPS observation regarding acting in XGY's best interest chimes with the first appellant's position that the officer in the case took measures to protect the respondent, quote, as much as she was able, unquote.
And sorry, what is the inconsistency between this response and the pleaded defence?
The pleaded defence makes reference to a communication with the prosecutor stating the only bail condition should be a non-contact provision for XGY and other members of her family. And the crime prosecutor does not appear to have been acting on that instruction on the CPS version of events, but rather dealing with matters
So
unexpectedly.
what paragraph of the defence?
17.
17, thank you.
17 little 3, my lady.
Is the police defence we're looking at,
It is, we don't have a
not the
defence.
CPS defence? Yeah,
We don't have a CPS
no,
defence, yes.
not quite, okay.
I say discordant rather than contradictory for this reason, which is we haven't seen the documents that would help us to work out where the truth of it all lies, what in fact happened, what was seen, what was not seen, and it's not helped by the fact we don't have a defence from the CPS, only that reply to the respondent's complaint. But on the face of it, there was no effective system even capable of discharging the assurances that had been extended to her to maintain the confidentiality of her address. Where the responsibility for that state of affairs lies between the appellants, or with both of them, remains obscure. We do know that the confidential information was disclosed without any form of risk assessment, and in the absence of the usual checks and balances that would operate within an evidential process, and which would apply to an officer coming to court to give evidence, to the preparation of the evidence of a witness, and for the preliminary examinations for those purposes. I've already made reference to the file standard checks that we see on the occurrence log. But in addition, had this risk-bearing information been proposed to a witness statement, it would have been captured within the usual process, of which those checks that we saw from the detective sergeant is only one element. And those are baked into the process to protect against unlawful disclosure, by which we mean disclosure contrary to the duty not to disclose, other than when justified in the public interest or required by law. And that's why, of course, the back of the MG11, the side that's not copied, is where all of the information regarding address and so on is recorded. And there are additional safeguards when the risk-carrying information carries this level of risk in light of the prior conduct and threatened conduct of this high-risk perpetrator. And the respondent does emphasise that the CPS advocate disclosed her confidential address at a time when it appears that he was not acting within the scope of professional instructions, and that therefore deprived this process of another potential check and balance. And I'll come to authority about why, for good reason, it is for the judiciary to adjudicate upon the release of risk-carrying information in criminal proceedings. But of course, if that information is not contained within the evidential process, that important check and balance is going to be knocked out of the system. The appellant's assertion that they did their best, that they acted in her best interest, is entirely rejected by the respondent. She has found it difficult to sit through the proceedings and hear of herself being described as not a victim. And we appreciate that that's for a technical reason. But her position is that, contrary to professional duties and obligations, her best interests and her legal entitlement to be protected from repeat victimisation were not addressed, were not dealt with. And that ultimately Mr. Justice Ritchie was entirely right to conclude that the appellants are in substance in this claim being sued as errant administrators. My ladies, my lord, you have the psychiatric report at S, supplementary bundle 26, the provisional schedule of loss at supplementary bundle 12. A fresh psychiatric injury, post-traumatic stress disorder caused by the April 2020 disclosure in the context of the vulnerability generated by the November 2019 disclosure, and real interference with her ability to work, losing her employment as a consequence of that psychiatric injury, notwithstanding a recent promotion, becoming overwhelmed in July 2021. And of course, the disruption and expense of being rendered homeless. I will return to that briefly in relation to Article 8 in particular. In relation to the legal landscape, I plan to dive straight into immunity and to address witness and advocate immunity through the authorities in parallel with one another. And the starting point, of course, is whether the pleaded causes of action arguably fall outside the protection of an existing...
Just going back to the facts, my notes
Yes.
said that under the heading of facts, you were going to deal with the procedural point at 112, the statutory guidance point, and the summary judgment point. When it's wrong.
No, my lady, they're not. In terms of the summary judgment point, sorry, let me take those in turn.
No, I mean, take your own course. I'm just making sure that I had understood.
Yes, but you're giving me pause for concern in terms of...
If you're doing it elsewhere, that's fine, but that's certainly what I thought you had fleshed out as being items to deal with in your factual section, but
yes,
I may have...
My lady, but not exclusively there.
Right, that's fine, that's absolutely fine.
I hope that what I have successfully done is to make good my submissions.
Not suitable for strikeout or something.
Regarding the uncertainty,
Yes.
and with regard to the gravamen of
Good.
the risk.
So legal landscape, yes.
Yes,
Thank
thank you, my lady. Legal landscape. I am pausing for one moment. Yes, my lady, let me check in the break because there is an element I had actually planned to include in this section, but I'll come, so you may well be right. But I'll double check in the short break that we'll have in about 30 minutes.
Thank you.
15 minutes, 20 minutes. In our submission that it is essential to begin with defining an immunity so as to satisfy the burden on the appellants that the alleged tortious conduct falls within it, is not to suggest that the facts must be examined in every case. Mr. Justice Ritchie concluded that the modern common law does not recognise the expansive immunity for which the appellants contend, And he did so acknowledging that there is no decided authority on these facts by considering what purpose an immunity of that breadth would serve. And he quite rightly concluded that the balance fell heavily in favour of constraining the immunity, in essence, although not definitionally, within the confines of witness immunity. The gist of the causes of action is not an allegedly false statement itself. There was no false statement at all. The gist of the causes of action is based on things that would not form part of the evidence in a judicial inquiry. And we find Lord Justice Lewison's analysis in Singh and Reading Borough Council at Para 66, and we will be coming back to this, particularly helpful in support of that proposition. We put the case that advocates' immunity in the modern common law does not, at least arguably, exist beyond the limits of witness immunity. And I make that observation as an introductory remark for the purposes of explaining why I'm going to the authorities in the manner in which I am. And it is immaterial whether the impugned activity has the potential to become evidence, because, quote, there's no good reason on grounds of public policy to extend the immunity to things said or done which cannot fairly be said to form part of their participation in the judicial process as witnesses.
Sorry, just repeat that for me, because there's no good reason allowing...
My lady, it might be preferable, because I'm actually quoting Lord Hope in Darker. It might be better if we actually look at Lord Hope rather than...
Just now you've got us going.
Yes,
because
absolutely.
No good reason allowing...
To extend it to things said or done, and then I lost you after that.
Let me go again. No good reason on grounds of public policy to extend the immunity to things said or done which cannot fairly be said to form part of their participation in the judicial process as witnesses.
Right.
And I am going to come back to Darker and put that in context. Obviously, that's
Darker, and what the paragraph reference in Darker is?
It is 447H within our bundle.
That's fine, but you're going to take us there anyway. Thank you.
Yes, I am. And how we put it is that whether the immunity is characterised as a witness immunity or an advocate's immunity, it does not adhere abstractedly to the judicial process. And it does not arise merely by reason of the function being performed. It does not concern general prosecutorial functions or police investigative functions or law enforcement functions, nor does it apply to administrative functions generally. And we're going to go to Darker on that proposition also. Now, I'm afraid there's cross allegations of misappropriation of the concept of wholly extraneous, because we also say that there is no test of wholly extraneous in relation to advocates' immunity. That is a term adopted by Lord Hoffman in Taylor to delineate the parameters of witness immunity. And let me deal with Taylor and some of the other more historical authorities before I move on to the cases I predominantly rely on, the House of Lords of this century cases.
So which is the case you said you predominantly rely on?
Essentially, my case is built on darker Holland Simmons, Jones and Caney,
Okay.
underpinned by understanding derived from the judgments of this court in Singh, Crawford and Jenkins and Daniels.
Right. So the cases you were referring to just there are Darker, Hall and Jones.
Yes, my lord, thank you.
But before you come to those, you say you're coming to Taylor.
Yes. Thank you, my lord. I suspect it's the heat, but I'm not entirely making that clear. So
I said yesterday I like a heading.
Yes. No, I entirely understand. Thank you.
It's very pedestrian, but I like a heading.
No, I like a heading also, my lord. So I'm going to Taylor just to examine whether this concept of wholly extraneous has any bearing or grounds any argument that the scope of advocates' immunity extends to anything unless it's wholly extraneous to the judicial proceedings. And clearly, as we know, Taylor concerned a claim to immunity in respect of a previously unrecognised immunity. And one was found to apply to the statements made by one investigator to another. The claimed immunity was upheld on the basis of that category's close analogy with witness immunity. And we can see that in Taylor, and we may have looked at this yesterday.
So around 264 and 5, do you want it?
Yes. Bear with me one moment, yes. So Authorities Bundle 264, so that's volume 1.
Two, 6, 4, which bit?
Yes, it's D all the way over to D to G. I believe you looked at the sentence at G yesterday, but we also rely on the preceding paragraph and the one before it beginning, thus the test is a strict one.
Right, so what's the point you're making?
Yes, that they're clearly dealing with witness immunity and not a broader immunity applying abstractedly to judicial process.
Why do you say that? Because at the bottom of page 264, it's talking about investigators.
Yes, but
I therefore agree with the test. In Evans, this formulation excludes statements which are wholly extraneous.
But the proper administration of justice requires that such people should have the same inducements to speak freely as those whose information subsequently forms the basis of evidence at trial. So we say that that is the analogy being drawn with witness immunity.
But then the next paragraph is about non-witnesses.
And bear with me a moment.
Which is what this case is all about investigators.
Yes, and then if we go to the If we go then, I am going to take this Taylor's development in darker, which is my more important point, but I seem to have somewhat lost my reference in respect of Taylor. So let me try and find that again in a moment. Bear with me one moment.
Yes, if you want to pause now, because Taylor is important for you. We've got to have a break anyway. Would you like a 10-minute break now?
Yes, that would be very
All right,
helpful.
very
Thank you,
good.
my lady.
Thank you very much. Let's say 10 to 12. Thank you.
In relation to Victoria Sharp's point about taking the facts favourably, some of the documents which are in the supplementary bundle which were disclosed after the strike application, like the scarf, so we didn't have that with them.
Yes.
Argue to was it originally talks about the scarf, which said the stuff about the drugs. Yeah, the guns, that stuff wasn't disclosed. So it's but with the quality assurance, everything we have is in the bundle.
So it's particularly
The scarf. No, we have the scarf. They said you said the scarf was reviewed. It doesn't say that on the scarf. I think that can be taken from the log. Yeah, I agree with that. And then they said
and I said in close proximity.
Oh, she's got some loaded. So, time are they coming back?
Then you didn't turn up to chance.
Okay, thanks.
I think he was asking what county is where she was living.
His pants look like this. No, it's not. It's because it's physical. It's because this is too tall. I need to. It's working now. We need a shorter. Sorry, we need a shorter pad so that it can air through. Do you know what I mean? Just against that. Try. Does it need to be leaned against something? If she moves that out, that will fall through.
That's everything I wanted to find. Bear with me a second.
They move, don't they?
Yeah, it's actually very loose. they say out in summaries. Pretty sure that's right. I think it was in 24 from memory. And then it's listed in there as well.
So you haven't dealt with the summary judgment. I'm going to come back to you.
She just said something.
Oh, she also said. She's only done with the first one, but the second.
That's okay.
Oh yes, yes, the harmful court. Harmful court. Harm crystallising in court. Which is right. Fiona, is it possible to go away?
It's not.
I know. There's a guy called Smarty. He's got it's
Yes, Taylor.
My lady, yes, Taylor. Let me take that a little bit more slowly. I mangled it, frankly. Where I think I can do that most straightforwardly is by taking you to the facts as the case developed, which is in the speech of Lord Hoffman in the core bundle at page 255.
Yes.
And if I could summarise them in this way, that the Serious Fraud Office was investigating the defendant and an individual assisting the police with their inquiries, Mr. Rogerson, this is at the bottom of 255 at H, offered his views with regard to the defendant and his complicity in his view as to his complicity in the criminality, going so far as to state in his view, working within the Law Society, he ought to be struck off as a solicitor, and that Mr. Taylor was a co-conspirator. So the cause of action runs against that statement as being defamatory. And so that is why we say that at the bottom...
Well, you obviously heard Mr. Beer,
Yes.
and do you accept that his criticisms were accurate? So, for example, this case involved not just a file note.
Oh, my lady, that's an entirely different point.
Right, okay, well then
and,
carry on with your point. Defamatory statement.
Yes, that this is a defamatory... I'm going to come to that point. 215... must be... Yes. Then at 215 in the judgment, page 265 of the bundle, as we follow through the considerations of what was occurring with, in the course of an investigation, allegations being made, having a close analogy with the basis for witness immunity, that then culminates in the conclusion at 215C, drawing the same policy.
Sorry,
215C. So after the passages
We're
that...
talking about internal page.
Sorry, 265.
Yes, 265.
So we see, following the analysis in which an analogy is drawn between the opinion expressed to the investigator in respect of which libel is pursued and the protection of witness immunity in respect of a statement. And then we see that important expression in our submission coming again in the first sentence at 215C. As the policy of the immunity is to encourage freedom of expression, it is limited to actions in which the alleged statement constitutes the cause of action. So that takes us on to Mr. Beer King's counsel's criticism. And what we say with regard to that is that what we're doing at paragraph 40 of our skeleton is addressing an entirely different point. The reason why we focus there on the term file note was to address, in fact, the first appellant's reliance upon Her Honour Judge Brownhill's conclusion at paragraph 90 to 91 of the first instance judgment, which is at page 322 of the core bundle. she says at the beginning of paragraph 90, well, you can obviously read it yourselves, my ladies, my lord.
Yes.
And of course, the file note in Taylor, we say, was a very different character. I'm not saying it's the only document that was under consideration in Taylor. We're just dealing with Her Honour Judge Brownhill, we say, getting the wrong end of the stick in considering an entry in a contact card having the same character as those opinions offered for the purpose of assisting the police with their investigations, and moreover, it is all the more strained when we're, of course, not suing because we say that that was not her address. We're suing because that address was not kept confidential. Where we see that term, coming back to this term, wholly extraneous, we see that also in Iqbal and in Daniels and in CLG. And I'm happy to give you the reference, but it's a very small point. They're all dealing with witness immunity. Before I move on to other elements of the legal landscape, if I could look back for a moment, because my lady, you did cause me concern that I had omitted an important factual matter which I wanted to emphasise, and you were quite right. And it concerns what happened at court on the 16th of April 2020. And this element of the documentation may not have come into focus because it appears as if it's repetitive, but it's the second occurrence log. It's in supplementary bundle 172. And you will recall that there's two occurrence logs, one relating to the original 6 common assaults and then the other relating to the more serious allegation that was subsequently made. And with these systems, records get repeated onto some and not others. And there will, of course, be other records relating to the breach of bail matter.
So 172, what are we looking at?
172, we're looking at the entry that is the 30th log entry. And we have an officer in the case pertaining to the common assaults in respect of the respondent, describing there sending across a new MG7, which we understand to be a remand application, MG8, which is a breach of bail conditions form, and a statement from the officer. We understand that to be the officer who was familiar with the circumstances in which he had failed to attend court in connection with the Brighton matter. There's reference to difficulties fully collating all of the issues that have arisen with regard to the perpetrator's non-compliance with court
And sorry,
bail,
and the point here is,
that documentation that's being prepared for court that morning relates to the breach of bail and not to XGY. So,
But just stopping there, I mean, when somebody comes before the court, before the magistrate's court, it's important the magistrates are aware of all outstanding matters, as they are,
one would have hoped so, my lady.
because you've got one person there, and if there are other outstanding matters, they need to be looked at the same time. One would
Well,
think.
my lady, as I understand,
So, for example, you can't have one court saying you can be released on bail when another court has already said you're in breach of bail conditions and you need to be kept in custody on different matters.
yes, no, I entirely follow that point, and I'm not seeking to disagree with how the process ought to operate. But what my learned friend, Mr. Jason Beer-King's counsel, said yesterday, as I understood it, by reference to the case building statutory guidance, that in presenting a file for the court that morning, the officers were under the guidance of a statutory guidance, that level of importance, requiring them to inform the court
yes,
of
we were taken to the charging guidance.
the charge. Well, in fact, what we know is that the charging advice had already been sought and obtained from the Crown Prosecution Service in respect of the 6 common assaults pertaining to XGY. They had dealt with that by way of a postal requisition,
No,
because
I understand that. I thought the point you were making is that these are two different. As these are two different matters, they should have been dealt with completely separately, and they
I'm
were
more
only
dealing with
one issue, not.
I'm more dealing with the point that the file that was being presented and the evidence that was being presented to the Magistrates' Court on the 16th of April was the evidence necessary for the court to deal with the breach of bail matter. And we see that from that element of the log and the documents that were being created. So it wasn't part of the police investigative responsibility or the placing of evidence before the Magistrates' Court to tell them where XGY was residing. The court was not dealing with bail conditions in respect of the common assaults. We do not know, and we do reiterate that we consider it singularly unhelpful that we've not been given those documents in order to ascertain what precisely went on. There is a number of potential scenarios, and we can only guess at what might have happened. We know from explanations, but not pleading, that the second appellant could not open some of the documents that were being sent by the first appellant, and they appear to relate to XGY's risk-carrying information, but that for some reason the advocate also had her address, and we say that that reason was not to do with the admission of evidence before the court that morning, nor was it intended to, nor would it ever have been. But that had it been necessary to establish XGY's address for the evidential needs of a bail hearing, that would have been diverted into a different process, and that process would have had the checks and balances that are associated with the compilation of evidence and the transmission of evidence between the appellants.
On the appellant's case, none of this makes any difference.
Because they have an immunity of such breadth,
Yeah.
it covers
So-
everything that is said and done by them.
So for you, this turns on the evidence theory, that there has to be justification. You support the judge below saying case by case?
No, no.
You don't?
Well, my lady, I think that criticism of Mr. Justice Ritchie arises from a unhelpfully granular unpicking of
Good.
his
So you
judgment.
don't agree with case by case. Do you agree with justificationism?
Well, I don't characterise it in that term. I just don't find it helpful for myself conceptually, and my lady, I've needed to keep my own clear eye on where I am.
No, that's very helpful. You accept wholly extraneous as a test for witness immunity.
Well, it's an unusual form of words in relation to witness immunity. It's only really used by Lord Hoffman and Taylor and then repeated in Iqbal and the other case that's gone out of my head.
When you say only used by Lord Hoffman and Taylor, I think everybody accepts that Lord Hoffman and Taylor is a pretty fundamental starting point.
Oh, absolutely, my lady. I just want, when we come on to look at Darker and Jones and Caney and Holland Simmons, we'll see.
Fine. So you say wholly extraneous for witness immunity. What do you say for advocate's immunity?
Well, that I'm coming to. Let me deal with that through Holland Simmons, if I may, my lady.
Okay.
Yes, I think before I then move on to Darker, which I keep promising to get to, but it is a very helpful case for the respondent's case, I just want to address the cluster of cases, the old cases, Cutler and Dixon, R.V. Skinner, Munster and Lamb. They're all defamation claims. They all relate to allegations voiced in court where the alleged statement constituted the cause of action. We find the observation in Jones and Caney in relation to Cutler and Dixon at, just checking, 681 in the bundle, which is volume 2. And we see there Lord Phillips helpfully summarising what we know, what remains of value from Cutler and Dixon by the time.
Page of Jones and Casey.
It's 681 in the second authorities bundle.
I've got the wrong.
And there's a red line just at F.
Yeah.
So far as Marinan and let's look at the name. Oh, sorry, Munster and Lamb is concerned.
And sorry, is there a point from Jones and Caney that you rely upon?
Yes, no, it's simply that Cutler and Dixon, R.V. Skinner and Munster and Lamb all dealing with matters arising from claims based on the content of the alleged statement, the statement being alleged to be untrue, defamatory, and so on.
But clearly extended beyond that, as we see from para 12.
Well, yes, but only where in respect of causes of action where the complaint arises from the content of the statement, such as conspiracy to injure.
And you say the complaint here against the CPS is not about the content of the statement?
Yes, we do, my lady.
And that is because you say it was accurate?
No, not because it's accurate. It's because it is not evidence. It is an administrative record entered into for the purposes of entirely different purposes to the evidential process. There's no statement, no need to prove whether for this purpose or any other purpose that she lives there. It's entered into a contact card as a matter of administration. that administrative function ought to have complied with the data protection principles, with the assurance given to XGY in respect to the confidentiality. And had it gone into the evidence stream, as it were, then we would have had those protections. Because it was not evidence, it didn't have those protections. And we say that that is material when we come on to considering whether an immunity of the breadth for which the appellants contend should stand, provided you're with me that the respondent has an arguable case that it doesn't fall squarely within an existing immunity.
Thank you. So Jones and Caney, you want us to go to Munster?
Yes. Now, so far as Munster and Lamb is concerned, my learned friend Ms. Barton, King's Counsel, stated that this was a case that was, quote, a true advocate immunity case. And in her skeleton argument, para 26 states that this authority confirms that the immunity not only covered claims for defamation, but any cause of action. And we say it's notable, even when looking at a case of that antiquity, that the facts clearly fall within the four corners of witness immunity. And we see that from the Master of the Rolls, Brett, at the Authorities Bundle 101 in the middle of the page, and in the head note. Emphasis on the cause of action being derived from what was said or done in the course of judicial proceedings.
And what's the distinction in this case? If we're looking at what was said in court, which was the, as it were, the event, could not the same be said about this case?
Yes.
Cause of action derived from what is said in court?
Yes, but nobody's complaining that there was a false statement giving rise to a cause of action. Nobody's suing on the content of the statement. We're not suing on the content of the statement. It's not
And
a claim.
is there any authority for the proposition that that's a material distinction? There's a material distinction between a statement that is false, as in inaccurate, a statement that should not have been made, and a true statement that should not have been made.
I don't seek to rely on such a distinction, my lady. What I do seek to draw a distinction between is, why are you suing? What is the function being performed? What is the statement? I mean, of course, everything's a statement in a way. Every record is a statement. But witness immunity and advocate immunity is bound within the evidential process. And that's the distinction drawn in Darker. And we say also, we see that in Daniels in particular. Let me move to Darker, because I think that might endeavour to assist me in explaining the position, the submissions I'm making. Now, you will have considered with care Mr. Justice Ritchie's analysis at paragraph 74 to 80 in the core bundle at 173.
I'm really sorry, but I'm just looking back at my notes. An earlier submission before we broke for a 10-minute break, he said whether there is immunity does not adhere abstractly by reason, or does not adhere by reason of the function being performed. And your submission just now, according to my notes, is that you're saying just that. You are looking at what function is being performed, and that is the distinction you rely upon.
I apologise, my lady. I'm sure I'm getting myself confused. But I'm not, where I am clear in my own mind, if not managing to articulate it, that you have to look to the cause of action. What is the alleged tortious conduct? Where did this occur? What is the complaint? And then you have to consider whether that falls within the scope of an existing immunity. And we say that witness immunity, and therefore advocate's immunity, arises in respect of the evidence and protects causes of action arising by reason of the content of the evidence. So yes, it is relevant that the defendant is participating in court proceedings, whether as a witness or as an advocate, but it is the nature of what has gone wrong, what is being accused to be tortious, that has to be examined to identify whether it falls within the class of immunity. So it's not looking at a case on an individual case-by-case basis. And so we see in darker this distinction that's drawn between the planting of drugs, in the example that's relied upon in darker, where that is not intended, the fact that the drugs have been planted is not intended to form any part of the evidence, albeit that to make good the conspiracy, it will become part of the evidence. It falls outside the scope of the evidential process, is not caught by the witness immunity, even though it could be seen to be connected to the evidential process. But let me take you through darker in respect of and here we fully agree with Mr. Justice Ritchie at paragraph 74 to 80 of his judgment. And it's probably easiest if I do this from Mr. Justice Ritchie's judgment, core bundle at 173. And no doubt you've read this with care. So I wanted to highlight the observations at paragraph 77, which are on page 176.
Sorry, which?
I'm sorry, paragraph 77.
Yes.
And what?
Do you say paragraph 77 is an accurate statement of the law?
Yes, I do, my lord.
Really? If they were investigating or enforcing the law, that would not be covered by the immunity. On the face of it, that was completely contrary to Taylor.
Well, my lord.
Which is about investigation and the letter to the Attorney General of the Isle of Man.
My lord, Taylor was about the content. The suit was in defamation based on the alleged defamatory nature of the content.
It was an investigation. It's all I'm picking up. That
But
I
the immunity.
I highlighted that sentence to myself in the pre-reading with a question mark.
Yes, but of course, the police no longer, if they ever did, enjoy an absolute immunity from suit in respect of the conduct of investigations. At the time that Taylor was decided, it was generally understood, although erroneously understood, that investigators and prosecutors benefited from a broad immunity from suit. Of course, we have now had the clarification that they are in no different position from any other defendant in circumstances where there is an assumption of responsibility. And although XGY does not bring a claim based on in negligence on the basis of an assumption of responsibility, because they were holding her confidential information, they had the same duties that would be akin to an assumption of responsibility in negligence, from which there is no broad immunity enjoyed by investigators or prosecutors if they ever did. So I think that's quite important, because as we go through these authorities, there is references to immunities. It's never entirely clear whether they're talking about what would have been called Hill immunity or the immunity recognised in El Ghazoli DAF in relation to the CPS, or whether they're actually talking about witness immunity, advocate's immunity, or so on, and so on. And that's why we think it is especially important to understand what is the definition that one's looking at. I don't take from Taylor, my lord, that what was being there recognised was an immunity in respect of investigative or law enforcement functions. I take from it an immunity in respect of the exchange of statements of a allegedly defamatory nature, the communication of those statements being a necessary and important aspect of an investigative function as it would be a prosecutorial function. But that doesn't mean that the immunity attaches to investigative functions.
Can I test your broader point in this way? So if I am an advocate and I maliciously defame a person, I'm immune from suit. But if I'm the same advocate and I inadvertently make or negligently make a statement that is not the cause of the action, that is an accurate statement that should not have been made, I'm immune. I'm not immune.
Well, you're probably not going to be sued, my lady, because, of course, the occasions when a claim can be made good against an advocate by a third party are tiny and a few. Because you will have not...
About the principle.
The principle.
Yes.
All cases about the principle.
It will indeed, my lord, and I don't disagree with that. But I think it is important that we keep on in mind what sort of wrongs are going to be needed.
Let me repeat it. If I maliciously defame somebody, giving rise to a cause of action for defamation, I'm immune if I say it in court. If I say the same thing in court, or I make an accurate but careless statement because it should never have been made in the first place, I am not immune.
May I ask this question about your hypothesis? Are you incompetently summarising the evidence?
That's what that makes all the difference, does it?
Yes, it does.
Right. So if I'm incompetently summarising evidence, I'm immune. But if I'm making a factual statement that is I should not have made, I am not immune.
Well, my lady, we don't say that the tort here was making a factual statement in court. We say that what happened here is that there was unlawful failure to maintain the confidence of that risk-carrying information. And this may be the point in time in which it might actually help.
This is not a hostile question.
I appreciate that entirely,
genuinely very interested in all of this. But is the advocate on every occasion to ask herself, now, am I incompetently am I summarising evidence? Am I perhaps saying something that might be untrue that could be defamatory? Or am I merely passing on an administrative piece of information in order to know whether or not I can speak freely?
Yes, well,
These are questions that
They're
the advocate
important
has to go through.
they're very important questions, and perhaps the way I can best assist is by responding to Dr. Van Dellen's evidence on this, because he deals with this in his statement in that bundle at page 50. And he gave a few examples, care proceedings. He gave an example of inquests, which I'd quite like to pick up on, because Dr. Van Dellen is an assistant coroner, so it's a jurisdiction with which he is familiar, and it's an area of practice in which myself and probably every other member at the bar is engaged in, so it's familiar to everyone. And what Dr. Van Dellen sought to describe was the impact of uncertainty, uncertainty of scope, upon fearless advocacy before a coroner's inquest and a coroner's jury. Now, this struck me as entirely odd. As someone with a significant practice in inquests of maximum complexity, sensitivity, and involving the handling of a great deal of risk-carrying personal information. That's almost my specialism, as it is my learned friends, Mr. Beer and Ms. Barton, King's Counsel. What I am not going to do when I'm handling that information is consider for 1 second what would be the litigation outcomes for me if I were to handle it in one way or another. What one is going to do, and I speak with confidence that this is the universal practice at the bar, is that you are going to filter between personal data that ought to be not disclosed absent a good reason, but to really focus in on the risk-carrying personal information, the address of a witness who is under threat being the absolute classic example, the example we have in this case. And the professional motivations that are going to see us all acting with great care in relation to that information is driven by professional motivations that go much deeper, which are much more deeply ingrained and much more powerful than any anxiety to protect oneself from being sued. But let me say this, that if, despite my efforts to conduct myself in a professional manner and in a manner that is compliant with the law, my duty to the court, and my instructions, and to act within the scope of my instructions, all of these things serving to protect me and the individual to whom the risk arises, if I were to tortiously, i.e. unreasonably, reveal the identity, the location of a victim such that that individual had to flee their home and that individual were to be caused by me financial loss, psychiatric injury, homelessness, then that would be the point at which you are grateful for all the occasions of your life that you've paid your professional indemnity insurance. And it would be your professional duty, if not as a barrister, certainly thinking back to my previous life as a managing partner in a solicitor's firm, the first thing that one would do is to inform the client of their right to sue you.
I think we're slightly, perhaps my fault, going off the point, but you say that there is no issue arising out of inquests and the inquest environment in terms of lack of certainty, because everybody is so clearly focused on these sorts of issues in the first place.
I do put it quite a bit higher than that, my lady. I'm saying that the common law has long recognised good reason, and there is a settled immunity, therefore, in respect of the inevitable requirement within judicial proceedings to discuss the evidence. Accurate evidence, inaccurate evidence.
Inevitable
Malicious-
requirement to discuss procedure.
Well, my lady, no inevitable requirement to chat about risk-carrying information, no.
Inevitable requirement to just discuss procedure. Would you accept that?
Yes, of course. But within that procedure, the responsibility resting with the judge and only with the judge to decide when risk-carrying information is to be revealed within the process. And we see that from WV, which is, and the CPS, which is in the bundle at 731.
So give me that reference again.
WV v Crime Prosecution Service,
Tab. just
tab
give me the-
27.
Yeah.
So that places it in volume 2 at 739.
Paragraph 79.
It starts at 731, and the point regarding the right to an independent safeguard is at page 739. Paragraph 29. Thank you, Mr. Paul.
Yes. So you were looking at darker in para 77.
Yes.
The learned judge's judgment below.
What Mr. Justice Ritchie is doing in those paragraphs, and this is in our view particularly apparent from paragraph 77 of his judgment, through his reliance on the citation from the speech of Lord Mackey at paragraph 78. And what he's doing there is he's relying on the underlying rationale for the asserted immunity to test whether the alleged conduct fell within its scope. And we say that in circumstances of uncertainty, that was entirely the correct approach. It was an exercise that was rendered necessary in darker because the cause of action did not, quote, depend as a cause of action on alleged statements relating to the preparation of evidence for proceedings, and went, quote, beyond matters of freedom of speech at or in the course of preparation for a criminal trial. There is no issue of freedom of speech in respect of the respondent's confidential whereabouts, quite the contrary.
Can I just ask you a question about that? Just to be clear, your pleaded case in respect of misuse of private information does rely on the disclosure by the CPS of information in court. That's how you've pleaded your claim.
My lady, if we look at the DPA claim, which is at paragraph 30 of the particulars of claim 372.
I'm looking at paragraph 31,
Pardon me,
for example,
I highlighted
page
this
373.
only this morning. Yeah. Sorry, my lady, you're quite right. It's the misuse of private information, which is understandably and reasonably grabbing in the breach of confidence claim because of the considerable overlaps. And if we look at paragraph 31D at page 374,
Well, I'm starting at the beginning of paragraph 31, because the rest of it is particulars, and it's asserted that the disclosure by the first and or second defendant of the address was a misuse of and or unjustified disclosure, and so on.
Yes, so just reading that disjunctively, the disclosure by the police of the claimant's address and information relating to such referred to above was a misuse.
And the disclosure and by the CPS as well.
Yes, it's either or. Thank you, my lady. And sorry, I think I misunderstood the point you were making, and I think that comes across more clearly from subparagraph D.
But the point is, how do you put your case then, when you repeatedly say that the disclosure is not the cause of the action? But you could say the same for the DPA claim at paragraph 30B, unlawfully disclosed.
Yes, so we're saying that the tortious conduct is the unlawful failure not to disclose, because the breach of confidence is a duty of retention, and it's debatable as to whether then breaching the confidence by reason of, other than in the public interest.
Every
or
positive could be framed as a negative, and every negative could be framed.
well, like I see that entirely, but I was only pointing out that there does seem to be a debate as to whether the requirements of lawful justification and or required by law are parts of the elements of the tort, which is my preferred view, or defences. But the tort is in its essence a requirement not to disclose without good reason, if I can put it broadly.
No,
and-
the tort is the breach of the requirement not to disclose, and the breach is the disclosure.
Well, I don't know whether a great deal turns on this, but I'm saying that the breach is not retaining the confidential information, not retaining the confidence. But I don't think anything turns significantly on that distinction. I'm probably being a bit pedantic, and I may not even be right. But what we are saying is that the act is the breach of confidence. The act is the misuse of the personal information. The act is the data breach. What the act is not is misstatement, malicious statement, incompetent statement of a set of circumstances. And that when we properly look at what's going on in darker, and we get quite a lot of help from Hall and Simmons in understanding all of this, is that the courts are analysing and either upholding or not upholding immunities that cover that set of circumstances. I may have a job of work to explain to you why there ought not to be an immunity in respect of the act of failing to protect the confidentiality of risk-carrying information. But in my submission I need to do at this stage is to convince you that we have an arguable case that it doesn't fall within the scope of an existing immunity. Once we get over that burden, which we clearly did, so far, of which Mr. Justice Ritchie was clearly convinced, then we start looking at the competing, balancing interests. And it's at that point that we would, of course, say that the preeminent interest is in affording a remedy for all of the very powerful dicta that we see replete throughout the authorities. And weighing against that in the balance, whether it would cause such grave difficulty to the conduct of judicial proceedings to give, in this narrow class of case, a remedy where things go wrong, and for all of that to be taken into account. And so My lady, that's why we say it is highly relevant that advocates are already highly motivated to deal with risk-carrying information with care, that we carry insurance in case we get it wrong, and that the protections that arise with regard to the evidence have really helpful echoes in the scope of the recognised immunity to date, because amongst other protections, that judicial oversight is active with regard to the evidence, but not active with regard to an advocate who stands up and decides that he knows what's best, and without instruction, information, or any other lawful basis, goes about revealing the victim's confidential location. We say that is all part and parcel of administrative functions performed by the Crown Prosecution Service and the police, and it hasn't formed part of the evidence in the judicial process, and therefore, arguably, falls outside the scope of an existing immunity. Staying with Darker and Mr. Justice Ritchie's analysis, we say that Mr. Justice Ritchie was entirely right to find assistance from the distinction drawn by Lord Cook between the evidence and conduct which is primarily and naturally to be seen as belonging to an investigatory function of the police, and by analogy, the Crown Prosecution Service, even though it may have some ultimate link with the giving of evidence. I think it's probably worth looking at that passage in Lord Cook's speech in its natural habitat, as it were, and it's just going to take me a moment because I have it marked up, but not in my note.
So tab 17 in Darker.
Yes, and it's Lord Cook.
He starts at page 333.
Thank you. Yes, and it's page 334 in the bundle. At D to E. And then the redlining at the bottom of that page, and
So
then
this is you want the grudgingly paragraph,
yes, and then most
the red line paragraph, do you? Yes.
most importantly, the paragraph at the top of page 335. Bear in mind that witness immunity is a general doctrine. And that's why we say absolutely critical distinction between the first appellant providing to the second appellant evidence concerning where the victim is residing for an evidential purpose, and the first appellant sharing confidential information as part of its investigatory function, or we actually think this is more an administrative function. And the argument that my learned friends have made here and below which is that, well, it might have become possible or necessary to prove where the victim was in connection with an allegation of breach of bail. Well, that's quite speculative, because properly considered there would have been no bail condition in relation to that address. But even if some ultimate link with the giving of evidence can be postulated in that way, it's not sufficient. And so we do...
It's not what, sorry?
I'm
Did you
sorry, my
say
lord.
It's not
Not sufficient,
not
my lord.
sufficient.
Sorry to ask another question. I know
No,
you're
please, I'd
putting a
much
lot of-
prefer questions than beating in the wind.
Just looking at what Lord Cook says, you've taken us to the paragraph lower down. If one looks higher up at what he says at, what he says at the beginning of it suggests that investigating a crime, in other words, the investigatory process does fall within the immunity. And then he goes on to say the fabrication of evidence, he says, it's really at A to B.
A to B on which page?
Where, I'm sorry, it's at page 334. Fabrication of evidence, for instance, is almost the antithesis of investigation. It is creation. So, I mean, I don't read him as saying, which I think was your submission of the later paragraphs, that he was, as it were, excluding the investigatory process. Or was that not what you were saying from the immunity?
What I think creates difficulty in this area of the common law is that one has cases where the courts, including senior courts, are looking at, for example, defamation and make statements, and then everyone says, well, that's all that's being said, or that is more than what's being said. There is replete references to the fabrication of evidence throughout Dark, but of course those were the facts that the court was considering. But when you're looking at a true immunity, whether the conduct falling within or without the four corners of the immunity is egregious or not egregious is neither here nor there, because it is a true immunity. And so we don't say, because of the obviously because of the outcome in Darker, that Lord Cook was concluding that investigative actions fall within the scope of this species of immunity. In fact, it doesn't fall within any species of immunity.
Well, he was saying that fabricating evidence doesn't fall within the scope of the investigatory process. And
Not only that, though,
Right.
my lady, he was giving assistance to us all on the scope of relevant immunities, and I think that's apparent in his concluding remarks at the bottom of page 336 over to the top of 337. That is giving rise to scrutiny of investigative actions within civil proceedings, not bound by a true immunity. May I seek to help further in respect of Darker by praying in aid Lord Justice Lloyd Jones in Daniels. I'm not going to deal with Daniels fully here, but in the authorities bundle at 894,
Now going to
Daniels Yes, I'm going to Daniel's judgment of this court, Lord Justice Lloyd Jones.
And that's tab,
Daniel's is at tab 34, my lord. That will place it in 2, thank you. There is a pithy summation at paragraph 38, a submission upon which we place reliance. We agree with it. That's what we think is the outcome from Darker.
Paragraph 58,
38.
38, thank you.
So rather than my stumble over what is Darker, I buy to higher judicial thought, well, to in fact judicial thought, high judicial thought.
And what point would you like us to take?
No, just simply that, I mean, that's, we're aligning our argument with that summation.
That we shouldn't be looking at Lord Cook or Lord Clyde in relation to advocates' immunity.
No, that's a correct drawing out of what they are in fact saying. No absolute immunity. The issue is whether the conduct challenged is connected with the giving of evidence or the making of statements. And we say what we're complaining about in this action has got nothing to do with the giving of evidence or the making of statements.
One reads that paragraph 39 as well.
Yes. Yes, we'd align with that also, my lady, because it's really important to appreciate. I actually conceptually don't find that element of witness immunity to be properly characterised as an extension. It's a necessary element of the core immunity itself, because the boundary line is not drawn by the witness box. The boundary line is drawn by the nature of the act being a deposition, the verb being deposing. And it's perhaps helpful to draw that distinction between deposition and statement as it occurs to me in this moment, because it's not any statement, it's an evidential statement.
Yes?
There's a critically important passage in Hall and Simmons upon which we place critical importance, and it's in the speech of Lord Hoffman. And I note the time, and perhaps a convenient way to approach this.
How are you getting on with your submissions?
Yes, I'm on track. I believe that even if we were not to allow, that I'm due to finish at 3:30 on the basis that I'm not stealing the time that wasn't taken by the Bar Council yesterday.
I think there should be an hour for replies. So finishing by 3:30, you think you're on track for that if we start again at 2 and we don't ask you too many questions?
Well, my lady, please do ask me questions. Ultimately, we'll get to what I'm endeavouring to explain much more speedily through that method.
Thank you very much indeed. Thank you very much indeed, Ms. Murphy. Good luck.